Bankruptcy is a condition in which the business has reached financial distress to the point where one party goes to bankruptcy court to petition that the other party takes a specific action. The two parties are the company themselves or the counterparty to whom the company owes money. The specific actions could be that the company liquidate assets, or it might be that they reorganize the business. Conversely, the company themselves may seek protection from the lenders while they reorganize. There are two separate chapters of the legal code that relate to these two types of specific actions, and they are Chapter 7 and Chapter 11. Chapter 7 bankruptcy involves the liquidation of the company who is insolvent. Chapter 11 refers to the process by which the company is allowed to reorganize. Whether a company is allowed to reorganize or is forced to liquidate is ultimately decided by the court. Lenders typically seek to have the firm's assets liquidated so that the debt can be repaid, limiting the risk of the lender as much as possible. But because there isn't normally much left over for the equity holders during the liquidation process, shareholders, and thus managers as their fiduciaries, will often seek to be allowed to reorganize the business and to be allowed to continue to operate. Ultimately, the court must decide on the value that will be created or destroyed by allowing the company to continue to operate. To make this decision, both parties will present their estimation of the business's value, both in liquidation and under the ongoing concern. Both sides are likely to call expert witnesses who will present valuation models, and it should be no surprise that the lenders will typically value the company higher in liquidation, claiming that allowing the company to reorganize and continue to operate essentially destroys value. And in this case, that value belongs to the lenders. Conversely, management typically presents valuations in which the company is likely to be worth more if allowed to reorganize. Again, bringing in expert witnesses and valuation consultants who will try to make the argument that the firm should continue to operate. This whole process usually starts for one of two reasons. First, the company cannot pay a bill. This is called flow-based insolvency, meaning that the cash flows of the company are not sufficient to meet their liquidity requirements. Alternatively, the bankruptcy process can be started by a condition that is called stock-based insolvency. This means that the equity holders have no value left in the company. In other words, the company's assets are more than 100% owned by the lenders, and as such, the equity holders no longer have a claim on the assets of the firm. Regardless of the reason, once the court decides if the company will be allowed to continue to operate or not, the next set of events kicks off. If the company is allowed to continue to operate, they will have 120 days to propose a reorganization plan that the lenders will review and vote on. One of the aspects I find interesting under Chapter 11 bankruptcy is when junior debt holders, those whose claims will be paid after the senior debt holders, realize that there isn't likely enough money to pay them off in full. At that point, they very quickly begin acting like equity holders in financial distress and push the court to allow the firm to reorganize. And they suddenly want the firm managers to increase their risk-taking. When the value of the junior debt holders' claims are no longer likely to be repaid, they begin to push for the same perverse behavior as the equity holders, hoping that by pulling the goalie, the firm will achieve a degree of success that provides enough assets to once again back their claims and make their debt worth something. This source of conflict among the debt holders is also the reason that the debt holders have to vote on the proposed reorganization plan. All of a sudden, not all bondholders see the situation the same way, and different groups are incentivized to embrace behaviors that they would find reprehensible under normal circumstances. Often, the reorganization plan will restructure the right-hand side of the balance sheet and propose that the junior bondholders be granted equity shares instead of their original debt positions. This then leaves the more senior lenders as the only lenders left for the company. If the court decides instead to liquidate the company, the absolute priority rule kicks in, and a trustee will be appointed to liquidate the firm's assets and repay the parties in accordance with the absolute priority rule, which simply follows this order, in which parties are paid what they are owed. As you can see from the APR, or absolute priority rule, not all claimants are lenders. Some are also employees or vendors, and in some cases, the court and the court-appointed trustees themselves. No matter how you cut it, bankruptcy is bad for a business. But sometimes it provides the equity holders the extension of time and the relief from some of the short-term debt that might let the company survive, while in other cases the process results in the liquidation of the assets so the funds can be dispersed to whoever has a claim on them.